I'm Carol Lawson, an estate planning and probate attorney in Clearwater, Florida. A question I am frequently asked is, why can't I have my child on my bank account with me? One of the things that I'm looking at is, how do you own your assets? Who actually owns their asset? Who is on their bank account? Who is on the title to their real estate? Sometimes I will discover that a client will have an adult child on their bank account with them. 98% their child is on that bank account for convenience purposes, such as if I'm in the hospital or traveling, or I otherwise need my child to pay my bills. For me, write out checks, they can do so because they're on the account. Unfortunately, there's a lot of downside to having your child on your bank account with you. Reason not to have your child on your account with you. The first one is liability. If your child gets into a car accident, gets sued, files bankruptcy, or files for divorce, then your bank account could be subject to that child's creditors or spouse. If your child goes out and accidentally runs over somebody, or they have a big judgment against them, and insurance is not enough to cover catastrophic damages, your cash in the bank is easy money. D, if your child is on that bank account with you, the presumption is that the money belongs to your child just as much as to you. You will have to go to court to prove that the money is actually yours, and you still may lose it. The second reason it's a bad idea to have your child on your bank accounts with you is because it could affect your child down the road. I met with a client recently who was in the process of applying for Social Security disability benefits. He is no longer able to work. Unfortunately, his application was denied because he is on his father's bank account, and those assets, even though it's not his money, he can access, which makes him ineligible for benefits. The third reason it's a bad idea to have your child as a co-owner of your bank accounts is because you're basically giving your kid carte blanche to your money. It's going to be very difficult to get any money back if your child steals money from you or mishandle the funds because you trusted him enough to put him on the account in the first place. Another reason it's a bad idea in a lot of situations to name your child as a co-owner of your accounts is because when you die, the bank account continues to belong to that one child. If you have multiple children and the intent is to divide the account among all of your children, it may not happen. The person on the account does not have any legal obligation to share it with their siblings. Even if your will says to do so, the ownership of the account controls over your will. Well, you might be saying, well, my child's going to do the right thing. Let's assume they did share the money. If it's a large enough amount and the child does share the money with his or her siblings, that is considered a gift now from the child to their siblings, and they might have the burden of having to file a gift tax return with the IRS to disclose those gifts, depending on the amount of the gift they may have to pay taxes. So how do we get around this? Remove your child from your bank account. Now it will take your child also agreeing to be removed, put it back just into your name, sign a power of attorney, naming that same child as your attorney, in fact, giving them authority to help you out with your banking. Give a copy of that power of attorney to the bank and your child. That child can continue to pay bills on your behalf out of your account and help you manage the account. Then, if you want to avoid probate of the account when you die, sign what's called a payable on death beneficiary form with the bank for that account. Whoever you want to inherit the account upon your death, that might be the one child, it might be all of your children, it might be your trust. Some financial institutions call it transfer on death form. By signing that form, you're naming beneficiaries for the account. All the beneficiaries will need to do is present a death certificate after you die, and the account will be dispersed among all of your beneficiaries. Be aware that some financial institutions limit the number of beneficiaries you can list to 2 or 3. If you are a Florida resident, we would be more than happy to help you out with your estate planning.